Welcome to this presentation about the power of an estate plan. Hi, my name is Greg Womack, and we are here today to talk about estate planning. And we, I've been in business since 1987. We started Womack Investment Advisors back in January of 2000. We're in multiple states and six dedicated staff members here in Edmond, Oklahoma. We assist our clients in growing and protecting their wealth. And one of the things I think it's important is that in protecting your wealth and taking care of your financial matters is having an estate plan. And, a common misconception is about estate planning is, maybe many people think, well, I don't have an estate or I don't need to worry about estate planning. But here's the truth. Everyone has an estate, including you. So you might associate the term estate with the sprawling mansions or massive bank accounts or brokerage accounts. However, in the context of estate planning, it's much simpler than that. So your estate is essentially everything you own, your cash, your bank accounts, your property, whether it's a house or a car, your personal belongings from furniture to jewelry, even your pets are considered a part of your estate. So whether your estate is large or small, having a plan in place is crucial. It basically ensures that your loved ones and your belongings are taken care of according to your wishes when you pass away. So remember, estate planning isn't just for the wealthy, it's for everyone who wants to protect what matters to them. So, as important as estate planning is, many Americans have not taken that step to write or finalize their will or revocable trust. In fact, almost two-thirds of Americans think it's important, but only about a third of Americans have an up-to-date state plan in place. So reasons given are, of course, procrastination is the number one. Other reasons include not knowing how to make a will or fearing the process will be too expensive or too complicated, or that the person has no individual heirs to pass to whom they can leave assets. So in fact, it can be quick, easy, and affordable, and that's why we're here today. I think it's important that you have an estate plan. We have, why having a plan is important for your loved ones. We're going to talk about the key differences between a will and a trust, how to make an estate plan, and how our partnership with Estately allows us to make estate planning easier and affordable than ever before for our clients. So we'll end up with some suggested next steps as we follow up from this session today. So we're not going to try to give legal advice. We're not attorneys, but we do have a lot of experience in the estate planning area. So, uh, consult us if you have any questions regards to complex questions when it comes to the laws, and we can get someone to answer those questions or get those answers for you. So let's dive into what estate planning actually is and the top 10 reasons why it's important. So basically, it's about creating a list of legal documents that determine what happens to your property after you pass away. But it's a little more comprehensive than that. So it includes allows you to basically, one, choose a guardian for your children, specify wishes for healthcare decisions, also to designate someone to make financial decisions on your behalf if you're incapacitated, pass on family heirlooms or trusted possessions to specific individuals. So if you've got a stamp collection or gun collection or art collection or this piece of art or that piece of art, you may want to assign them to specific individuals who receive different ones in your heirlooms or your collections. Also, you make donations to charities you care about. So the process involves creating these plans and keeping them updated. The main documents in an estate plan are typically a last will and testament or a living trust. You also have an advanced healthcare directive and a financial power of attorney. So it'll also include organization and maintenance of the beneficiaries on your financial accounts, like a 401k or IRA or insurance policy. And so just keep in mind the decisions you make during estate planning can significantly impact your assets, your your future care, and the legacy you leave behind for the people and causes that you care about. Having a will is crucial. Um, so that's the basics estate plan. Um, is for everyone, no matter how much or little you own. So basically, it ensures that your financial wishes are known and your loved ones are taken care of after you're gone. It also lets you decide what happens to your stuff, your kids, and even your pets. So if you don't have a will, you're leaving a big decision up to the courts. And basically, they get to say then who gets your things or looks after your kids. Plus, if you don't have a will in place, it can make things really tough for your family after you're gone. So we dive into the 10 most important reasons to have a will or an estate plan is basically it's going to make things easier for your family. Almost all estates have to go through probate court, particularly if you don't have a will, it has to go through probate court. If you do have a will, it still goes through probate court, but at least there's a listing of assets, process of distributing your assets and who you want them to go to. But when you don't have a will, this process is called intestate administration, and it can get really complicated. The court has to name someone to handle your estate if you didn't have a will, which can take a lot of time, cost a lot of money, and cause arguments among your loved ones. So having a will makes this whole process much smoother and is one of the best ways to save your family time, money, and stress during a really already tough time. Number two, it picks who's in charge. When you get to make a will, you get to choose an executor. This is the person who will be in charge of wrapping up all your affairs. It's a big job. It can include everything from closing bank accounts to selling property. Um, so you should pick someone you trust who's good at handling this kind of thing. If you don't choose an executor in your will, the court will pick someone for you, and it might not be the person you want. Number three is decide who gets what. So your will lets you say exactly who should get your stuff after you're gone. You can name specific people to get certain things, as I mentioned earlier, and you can also say who should get anything left over. So the executor you choose will make sure everything goes where you wanted it to. So something people don't always think about is that you can also use your will to make sure certain people don't get anything. For example, you may want to keep an ex-spouse from getting any of your things, or if you've helped one kid go through college, you may not want to make, or you may want to make sure that the other kid gets a fair share of what's left. There's also stories of children who basically are no longer in touch with their parents, and whatever the issues, you can disinherit a child or other person as well. So you want to look after your kids. Number four, if you're a parent, you can use your will to say who should take care of your kids if something happens to you. This is particularly if you have minor children, this is critical. The person who's handling the executive of your state may not be the best person to have guardianship over your children if younger children, if something happens to you. Also, special needs. If you have a child who is, disabled or requires special needs care, you definitely want to, you know, put down who's going to be guardian for that person. And there's also some protective things there to keep in mind on a special needs trust for a child that needs special care. So usually, if one parent dies, the other parent gets full custody. But if both parents pass away, this becomes, super important is to listing guardians. So the guardian you choose will be responsible for your kids' daily needs, food, housing, health care, education, the works. So if you don't name a guardian in your will, a court will have to choose one for you. This could mean someone you wouldn't have, picked uh, anyway to raise your kids. So it's important to to choose your guardianship. And sometimes listing a second guardian in case the first one couldn't serve in for the children. Five is take care of your pets. So having a will is really important. You can use your will to make sure someone takes care of your furry friends after you're gone, and they have the monies to do so. Uh, the law sees pets as property, so you can't leave money directly to your pet in your will, but you can name someone to take care of your pet. and, have them some money to set aside to take care of those expenses. This way, your pets will be looked after by someone you trust. Number six, handle your online life. So these days, we all have tons of online accounts and digital stuff, things like Facebook, email, photos, videos, maybe even domain names, and also cryptocurrency accounts, which is a rising assets. As people are using more and more cryptos. In your will, you can name a digital executor to handle all this after you're gone, or it can be the same person as your executor. You can say who should get your digital things and how you want them handled, like if you want certain accounts closed. This helps make sure your online life is taken care of the way you want and your legacy protected as well. Number seven, keep the peace. So if your family situation is complicated, having a will is super important. Um, we've probably all heard horror stories of families, where the things weren't specified, and then children come in, or other situation, other persons who are part of that, feel like they want this or that, and it could cause a lot of problems. So when you die without a will, your family has to guess at what you would have wanted, and let's face it, they may not always agree. So this can lead to arguments and fights that can last for years. So by creating a will, you take away all the guesswork, and you can spell out exactly what you want, which can help keep the peace in your family after you're gone. Number six, number eight, support causes you care about. So many people want to leave a positive mark on the world after they're gone. And so a great way to do that is to support charities or causes you really care about. And so you can write your will, you can choose to leave some of your estate to a charity. It's a wonderful way to support causes that are important to you and leave a lasting legacy. Number nine is provide funeral instructions. So you may not want to think about your own funeral, but if you do it now and leave instructions with your will, you can make things a lot easier on your loved ones later. So while these instructions aren't legally binding, they can give your family an idea of what you wanted. You can name someone to handle the arrangements and suggest where you'd like the services to be, or say, where you'd like your final resting place to be. What songs you'd like played at your funeral, or people that you'd like to speak, etc. So you can make requests about the specifics on the ceremony. So number 10, it's easy to gain peace of mind now. So some folks put off making a will because they assume their family will automatically get everything anyway, but that's not always true. Probate can be long and expensive process for your heirs, especially if there's no instructions. Plus, a will only covers your current situation. You should update it as things in your life change. When you create or update your will, you're looking after your loved ones and giving them a clear map to follow after you're gone. This can really give you peace of mind now, knowing that you've taken care of these things. So before we dive into how to create a will, let's look at the difference between wills and trust and see what you might want to consider in your estate planning. All right, so both of these tools can say what happens to your stuff after you're gone, but they work a little bit differently. So a will is like a set of instructions you leave behind. It's a legal document. Um, you spell out who gets what after you pass. This includes your house, car, bank accounts, and even your pets and so on. But here's the thing, a will only kicks in after you die, and it has to go through a court process called probate. So this means it becomes public information. Uh, and so, you know, you just want to make sure you keep it updated over time, like a trust as well. But now a living trust is a little bit different. And so it's like creating a special box for your stuff. So you put your assets into this box, and you pick someone called a trustee to manage it. So many people choose to be their own trustee at first, which means you still have control over everything while you're alive. And typically, most revocable trusts, you're going to have you as an individual as trustee, or if you're married, you have your spouse as a co-trustee. So you control everything like you do now, but it's in the name of a trust, and everything's entitled in the trust. So the cool thing about a trust is it starts working. So it's a living, breathing document, whereas the will is upon death, it takes effect. Now, the trust doesn't have to go through probate, so things can happen faster and move more privately after you're gone. And so, the only downside to a trust I see is that, when you buy something new, whether it's a car, a new piece of property, or, set up a new account somewhere, just you want to make sure it's the name in your trust. If it's not in the trust, there's a thing called the pour over will, which we'll touch on in a minute. That pour over will they have an executor, it'll go through probate on anything that's not in the trust, and it will pour it back into the trust. So it follows the terms of your trust. So both wills and trusts, they have their pros and cons. And so really depends on your situation, but typically the cost of setting up a living trust is not much more than the will package, which we'll touch on later, and it may be to your benefit to consider that. So kind of the key difference is the will kicks in after the death. It's like a list of instructions that gets followed once you're gone. A living trust, on the other hand, starts doing its job as soon as you get it up. It's active while you're alive. It continues to working after you're gone. The big thing about is probate is, you know, it the living trust avoids probate if everything's listed in the trust. And those assets aren't listed in the trust, it would just be probated. But it makes things much easier. I can tell you this, that over the last 30 some years that we've been helping our clients do estate planning, we've settled out numerous amount of states, of estates, and those who have a trust that have everything in the trust, it is so much easier. Things could be started settling out as soon as you get a death certificate. Whereas through probate, it could take 60 to 90 days or even years in some cases to settle that out. So living trust, you could skip probate altogether. This means your heirs can get their inheritance faster and with less hassle. Privacy, trusts are private, wills are not. Uh, Also, maintenance, they're about the same. But only thing is, on a trust, you just want to make sure if you buy new assets, you want to make sure that they're in the name of your trust. Um, so basically, these differences can help make a big impact on how your estate is handled. So it's really important to consider them when deciding. And basically, some people think, well, you have to have a large or complex estate in choosing a trust. Not necessarily. And you know, while a simple will works for many people, there are some institutions where a trust might be a better fit. But if you have a large, more complex estate, or if your property in multiple states, this is a big issue here. Trust, if you have the piece of property, vacation home in another state, and you have that entitled in the trust, it doesn't go through probate. Whereas a will, it would. And in those states, property in other states would have to be probated within that state before your domiciled state where you reside is completed. So it can delay the process. So if you have any of these areas here, it's really privacy concerns. If you're concerned about that or special circumstances, a trust would be beneficial. Okay, so basically, when you're creating a will, you decide, you know, basically how are you going to do it? You've got options. So today's technology, it's easier than ever to establish a will and last testament. There's online tools you can use and software. Most of these are free, possibly, and land and who or other smaller costs to just get a basic will and as far as a legal document. Or you might hire an estate planning attorney, especially if you have a complex situation, a lot of assets, or if you're a business owner, or you have complicated family dynamics, or you simply feel more comfortable using an attorney. And there's also many templates and kits, and I would suggest you be careful with these because sometimes they can cause more problem than they solve. Um, you want to make sure that the if there's kits and templates you're using, that they're up to date and according to the most recent state laws in the state which you live. So it's better to get an assistance of legal counsel if you're going to be setting up an estate plan. Basically, you also want to list all your assets, everything you own from your car to bank accounts, even your pets. So, and you also don't want to forget family heirlooms or collectibles, personal items that are important to you. One thing to remember about retirement accounts and life policies, like life insurance, they're handled a little bit different. They're handled by designated beneficiary. So you want to make sure your beneficiaries are up to date because it goes directly to them. It doesn't pass through your estate plan. Um, and so we'll talk, we can talk more about that one-on-one. If you guys have questions on should you leave, if you have a trust, should you leave the life insurance to the trust. In most cases for IRAs, you don't want to list a trust or the estate if you have a spouse or children, because they can inherit them with less taxation versus just leaving it directly to your estate or your trust potentially. So there's things that need to be reviewed, but you just choose your beneficiaries, be specific, use full name relationships. It's okay to ask your loved ones if for input, especially for things that can't be split, like a family heirloom. Select an executor. Number 4, a person who will carry out your wishes after you're gone. So you want to pick someone reliable and organized. It could be your spouse, an adult child, or even a professional such as an accountant or attorney. Number 5, you want to choose guardians for minors. So if you have kids under 18, this is crucial. So you're going to choose who will take care of your children if something happens to both you and their other parent. So it's a big responsibility to make sure you discuss it with the person you choose. And then you want to choose financial and healthcare decision makers. So in the event you're incapacitated and can't make your own decisions, you'll need trusted people to make decisions for you. So these people you'll name in your financial power of attorney and advanced healthcare directive um, basically will be helping you make decisions for your behalf if you cannot make those for yourself. So you can give various people different amounts of decision-making authority when it comes to your finances and healthcare decisions. So remember, planning ahead makes this whole process easier. Believe me, we've got a number of clients who didn't have a durable power of attorney or a healthcare power, and the courts have to get involved, appointed guardianship, and you have to report to the courts. So taking time to think about what you own and what you care about and what kind of legacy you want to leave now, this will make steps much simpler to work through in the event something happens. So basically what to include, it's going to be a will or a living trust. You want to check your beneficiary designations. And these are all things that we assist our clients with. You want an advanced healthcare directive. You also need a financial power of attorney, uh, review insurance policies and financial information, proof of identity documents, titles and deeds of property. Look at your digital accounts, logins and passwords, and then also funeral instructions and wishes. So these are the things you'll want to include in your estate plan. Now, when you store it, you store your estate plan once it's completed. I'd suggest you keep probably original either in a safe. It could be at a safety deposit box. You definitely want to keep another copy somewhere else in case you can't get to the safety deposit box. Some banks may um, restrict access if they find out someone's deceased until they get legal documents to show the person can get in and get the safety deposit box. But if you have a home safe, something that's waterproof and fireproof, keep it with your financial advisor as well. We keep track of all of our clients' estate plans to make sure that we can assist if something were to happen. And then if you want to avoid probate, you don't want to put it with a probate court, but that's there if in the case there's a will involved only. And also we make digital copies for our clients they can keep somewhere safe, such as a safety deposit box as a last effort or fail if they just need an extra copy somewhere. Uh, when should you update your estate plan? Some people say every 3 to 5 years. I don't, unless there's been major estate law changes or other life events like getting married or divorced, having children or grandchildren, maybe buying new assets or moving states, definitely one, death of a beneficiary executive. These are all things, events that would trigger to update or review your estate plan to see if it needs to be updated. Now, we've teamed up with a company called Estately, and to help make estate planning easier, more accessible, and affordable to all of our clients and prospective clients. So if you're not a client of ours, we would encourage you to go ahead and do an estate plan. Naturally, if you want to use us, we'd be glad to assist you. But our clients, we do go over these with every one of our clients. So we partner with a company called Stately. So what is a Stately? Basically, it's it's an online, but they do have attorneys on staff that for all 50 states. They've done over 1 million estate plans. They have the highest trust rating by customers and also endorsed by industry leaders, as you can see down below on the presentation here. So making a plan can be easy and affordable. Many people fear estate planning will be complex or expensive. It doesn't have to be. And we have years of experience. Through our process, we can help you sit down and go through that, make it easy. Estately has a very simple tool that you just get online and start putting in the information. They once we reviewed it, they complete the documents and send them directly to us, and then we can help you, basically execute those documents, notarize where needed be, and also witnesses. So estate plans made using Estately are specifically tailored to your jurisdiction, to your state, so know what state you're in. So one, it's affordable, available from the comfort of your home, quick and easy, just 20 to 30 minutes to complete typically. Creates a legal will customized to your wishes, or can be paired with an attorney for complex estates, or if you choose to do a revocable living trust, all 50 states as well. So here is basically our cost investment to get your estate plan in order. If you just want a will-based plan, which includes the last will and testament, the financial power, healthcare directive, and the HIPAA authorization, starts at $395. Trust-based plan, which includes the trust. A portable will, basically, it will include, which says if you forget, something happens where you didn't get everything transferred into your trust, you have a portable will, which has an executor, typically the same, the successor trustee that you have in your trust plan. The executor would then probate those assets and have them put into your trust. But it's just kind of a safe all catch-all. But that's included with the financial power of attorney and the healthcare power, the HIPAA authorization, and that includes a quitclaim deed to file, say, to your residence, to put your home property entitled to that into the trust, and you file it at the courthouse. So we'll do one quitclaim deed. If you have multiple properties, typically they're $50 per quitclaim deed. So basically, if you just have a house bank accounts and brokerage accounts, and we help with the brokerage accounts, getting those set up into the trust name. If you just say, hey, I've got, don't have much, I just need a financial power of attorney and healthcare directive, you can get it for $195. So as I mentioned earlier, this is affordable. We want all of our clients to have an estate plan. I think it's very, very important to take this step. So what you can do, if you basically can scan this code, and you'll receive you can register to start setting up. Basically, just scan the code and it'll pop up. You can get online, and we will also get a notification that you have started this process. Or you can just contact us at area code 405-340-1717. You can email Megan, who's kind of our main contact, to get things started. Or if you want to talk to me, you can if you have any questions about your financial situation or specific questions on your estate planning, feel free to give me a call. We want to thank you for attending, and we look forward to assisting you in your estate planning needs. Thank you so much.